Hi everyone, welcome everyone to our webinar on navigating commercial disputes. My name is Aneela and I'm a Senior Associate in LegalVision's Disputes team, and I'm joined by my colleague Hammy, who's an Associate in LegalVision's Commercial Contracts team. So before we begin, a couple of quick housekeeping items. There's no need to take lots of notes. You'll receive a recording and slides via email, but feel free to submit any questions that you have in the chat box and we'll answer them at the end. We would be really grateful if you could complete a feedback survey after this webinar. Just to let you know as well that all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So moving on today, we'll be discussing common causes of commercial disputes, steps to take if something goes wrong, why working with a lawyer may help you, how to resolve claims without going to court, and if you do go to court, what that will involve. And at the end of the webinar, we'll be answering some of your questions, so please submit your questions throughout the webinar through the chat function, and we'll answer them at the end. I'll now pass over to Hammy, who's going to discuss common causes of commercial disputes.
Thanks, Aneela. So there are a number of reasons that a commercial dispute might arise, but before we jump into those, what is a commercial dispute? A commercial dispute is a disagreement that arises between businesses, generally over the provision of goods and services. Typically, a commercial dispute will relate to some sort of contractual arrangement that the parties have entered into, whether that be via a written contract or a verbal contract. Some of the most common causes that we see of commercial disputes include ambiguous or unclear agreements. So the documentation that was drafted was done so in haste and it doesn't accurately reflect the parties' intentions, or it's incomplete, so it hasn't been signed correctly, hasn't been dated, it's missing key provisions, things like that. Often disputes can also arise because there is no contract in place. So there's no document that sets out each party's expectations. There's been a few verbal conversations, maybe a handshake, and that's been it. The parties don't have anything to turn to when their expectations don't align, and that typically aggravates a dispute as well. And then finally, a breach of an existing contract. So there's a contract in place, but one party has breached a term of that contract, or one party thinks that the other party has breached a term of that contract. And because of that, the situation typically, there's a bit of fuel added to the fire, and typically the situation gets worse. So some really practical tips about what to do if something does go wrong. Firstly, keep things friendly. You're much more likely to get a positive response if you're being friendly and inviting the other side to the table rather than going in guns blazing and making accusations. You want to keep lines of communication open. It's really difficult to resolve a dispute if you're unable to communicate with the other side. If you've pissed them off to the point where they're just going, no, we don't want to talk to you anymore, it can be really hard to negotiate and resolve things. So genuinely try and work with them to come to an amicable resolution. You also want to put everything in writing and keep detailed notes. So if you have a Google Meet with the other side, or if you have a phone call with the other side, summarize your conversation, take some file notes, maybe send the summary to the other side. If you're engaging a lawyer or involving a mediator in your negotiations, it's a lot easier for that third party to come in and read the notes and the communication and establish a timeline rather than getting involved in a game of he said, she said. It's also really useful to be familiar with your contracts, know where to find them in your business's filing system, have a read of them and familiarize yourself. Sometimes they will set out very clearly what needs to happen when a dispute arises. So this will tell you what steps you need to take, whether certain notice needs to be given or whether certain pre-litigation steps need to be taken before either party can pursue a claim. It's also useful to look through the contract and read any provisions that are relevant to the dispute itself, so the actual issue at hand. For example, if it's a dispute about a party's failure to pay for goods and services that have been provided, have a look at what the contract says in terms of what goods and services need to be provided and what timeline they need to be provided in. Also have a look at the payment provisions. What do they say in terms of what happens if the payment is late? Can one party charge interest, or can one party simply terminate the agreement? and really have a look at what needs to happen and make sure that those steps have been taken. So if you need to provide notice before you can start charging interest, has that notice been provided? It's also really important to actually know what the issue is. So what is the dispute actually about? Oftentimes, a situation can get aggravated because lots of little issues pile up, but there will typically be one matter that's at dispute, which is the whole reason the parties are in this dispute. And have a think about what that core issue actually is. Is it that a party hasn't made payment as they were supposed to? If so, how much do they owe? How late are they on their payments? Really understand what it is that you're arguing over, and forget about some of the other smaller issues that are adding fuel to the fire. You also need to make sure that you're not doing anything that might cause you to breach the contract in response. So for example, we recently had a client who had a contract with another business that they were working with. The other side breached that contract, and our client took some steps in response to the breach before they sought our advice. But the steps they took actually caused them to in turn breach the contract, which added fuel to the fire and aggravated the matter further. Now, the court will always view the party that's coming to the table with clean hands favourably, and if both parties have breached the contract, neither party is coming to the table with clean hands, and therefore neither party has a one-up on the other. So you will always be in a better position if you haven't breached that contract yourself. And then finally, get legal advice early. Lawyers are a really useful tool in resolving disputes, and in the next slide we'll go on to why that is. But to give you an example, we recently had a client that came to us because they wanted to get out of a contract that they had entered into. There had been some breaches of that contract on the part of the other side, and so our client was ready to terminate the contract effective immediately. We took a look at the contract, and upon reviewing it, we found that there were actually some notice requirements. So our client needed to give the other side notice of the breach, and they needed to give the other side a chance to remedy that breach. Had our client not sought our advice before taking any steps, it's likely that they would have opened themselves up to potential claims for breach of contract. So what's the benefit of working with a lawyer? Firstly, it can remove the emotion. Generally, your lawyer will be a third party that isn't emotionally invested in the dispute. And therefore they can provide you with commercially pragmatic advice and provide solutions that you might not have thought about. You can decide how much or how little your legal team is involved with your dispute. Your lawyer can start by completing an assessment of the dispute and giving you advice on your legal position and the different options that you have to manage the dispute. They can, work through some options with you. They can help you determine, has there actually been a breach? If so, what should you do about it? They can talk you through some strategy and weigh up the options and the commercial elements of the dispute. What would you be looking at in terms of cost if you were to litigate? Is it worth it? Is it more sensible to work something out between the parties commercially? These are all really relevant questions that your lawyer can help you with. From there, you can keep your lawyer in the background. They can give you advice at each stage and you can handle the communications with the other side. This is usually the best option when you're trying to keep discussions friendly, because as nice as we are, us lawyers tend to scare people away and make things a lot more serious than they actually are. But alternatively, if you've already tried managing discussions yourself and you're not getting the resolution you'd like, your lawyer can step in at any time and take over. So this can involve communicating with the other side, managing any negotiations or settlement discussions, and ultimately finalizing any agreement into a formal document, which Aneela will talk about in a bit more detail shortly. Getting legal advice early means you've got someone in your corner that can help you resolve the dispute as quickly as possible and in the most cost-effective manner, which is ultimately what everyone wants to happen. So I'm going to hand over to Aneela now, who's going to talk through some options for resolving disputes without going to court.
Thank you, Hammy. So unfortunately, the court process can be very lengthy and expensive, but there's a lot that a party can do to try and resolve the matter themselves. In fact, the courts will sometimes want to see evidence that the parties have at least attempted to reach a resolution before court proceedings are issued. So one of the first things that you could look to do to resolve a potential dispute would be to undertake without prejudice discussions or have without prejudice meetings. They are really useful tools that can be used as correspondence, because correspondence marked without prejudice can't be admitted as evidence to court later on. The purpose of sending a without prejudice letter is to encourage open and honest discussion between the parties without the risk that the letter will be used against them at court later on. The most common use of without prejudice correspondence is to discuss settlement or settlement offers, and it's a really good way to put forward an offer without admitting liability. For example, if you have a matter and you think, you want to just take a commercial view of the matter, you want to resolve it, you can make an offer on a without prejudice basis without admitting any fault or liability. And the offer can't later be used against you if negotiations fail. Offers to settle can be made at any stage, and without prejudice offers are only disclosed after a trial and upon the discussion of costs. So it's a really useful tool, really. Another way that the parties can try and resolve things before court is simply sending letters, sending an open letter. Now, an open letter is different to without prejudice letter in that it can later be used as evidence at court. But this letter will, basically set out the facts very clearly. And the nature of a letter is that it usually serves to escalate things. It will help the parties narrow the issues. And actually, when you instruct a lawyer, this is normally the first thing that they'll look to do. Essentially, you're setting out your legal position and you're advising the other side that if this matter went to court, this is what your claim will look like. So again, a really easy and a really useful tool, really, to make your case really clear. Another course of action that parties can take to resolve matters themselves would be mediation. Now, a mediator is a neutral third party who will try and assist the parties to reach a negotiated settlement. Mediation can also take place where the parties' legal representatives attend a settlement discussion. The process usually involves both parties making concessions and compromises. And mediation can actually be really successful, and we've had a lot of positive results here using mediation. Sometimes when you're sending lots of letters and that you're toing and froing over a number of months, a lot of progress can be made in, for example, like a one-day mediation. The parties can be put a lot closer, and a lot of the issues can be dealt with sort of when the parties are just together in two separate rooms or in one room together, for example. So yeah, mediation is a really valuable tool to consider if you've got a dispute. Another option is taking the matter to arbitration. Now, arbitration is where the dispute is submitted by agreement between the parties to an arbitrator who makes a binding decision on the dispute. Sometimes contracts will actually have a clause which specifies that any disputes arising from that contract will be resolved through arbitration. The arbitrator's decision is legally binding, and the decision may be enforced throughout the courts if necessary. Increasingly, we're finding that arbitration is a really popular choice because decision is made within a matter of weeks, and it's just much quicker than proceedings, really. Another option, which again is the courts are sort of favouring at the moment, would be early neutral evaluation. This is where an expert is instructed to give an early opinion on the case to assist the parties to reach settlement. The expert's opinion is not actually binding upon the parties, but it just serves as an informed opinion to help the parties make an informed decision about whether they should proceed with the case or not. This process often motivates parties to explore settlement options and saves a lot of time and litigation costs. So finally, the last one there is offers to settle, and I think we have discovered that we had discussed that initially. But again, offers to settle can be made at any stage throughout the claim, and again, it is a really useful tool. If you do manage to agree a settlement, then it should be reflected in a settlement deed and release. This is a legally binding document which ultimately outlines the terms and conditions agreed upon for resolving the dispute. The deed will include provisions for the release of claims and liabilities between the parties as part of the settlement process. So it's actually a really important document, and you should always think about putting one together if a settlement is reached. So the next slide is a sort of general overview as to the claims process and what it involves, really. So if your attempts to resolve the dispute are unsuccessful, it might be helpful to know actually what do proceedings involve. The starting point would be sending a letter before action, really. Before proceedings can be issued, a formal letter before action should be sent to the defendants. The letter should comply with the relevant protocol. For example, if you are seeking payment of a debt, you need to ensure that the letter complies with the pre-action protocol for debt claims. In this letter, you need to outline the details of the claim, include details of the alleged wrongdoing, losses suffered, and the desired remedy. You also need to give a period for the other party to respond. So either 14 or 21-day period should be given for the other side to provide their response. Another thing to bear in mind would be limitation. There are strict time limits in which claims like this can be brought. For commercial contract disputes, the limitation period starts running from the date of the breach, which is 6 years. So you've got quite a significant amount of time there, but it's always important to bear that time limit in mind. So if you've not been able to reach a resolution, you can go ahead and issue proceedings. And to initiate court proceedings, you need to submit a claim form, particulars and documentary evidence to the court. A court fee would need to be paid, and sometimes a particular court should be used. So just bear that in mind as well. And once the claim has been issued, the other party will have 14 days to acknowledge the claim. And if they do acknowledge it within 14 days, they will then have another 14 days to respond to the claim. If they ignore the claim form and they don't respond, then actually you are able to enter what's called default judgment. And this usually happens when one party fails to engage in the legal process. It's also important if you are on the other side of the claim, you are receiving a claim form, it's so important to remember that they are time sensitive, and you do have set time limits to comply with them. And if you sort of ignore those court claims, you risk having a judgment entered against you or your company. So really important not to ignore them, really. So if the matter is defended, then the court will manage the case and set deadlines for various stages of litigation. And the first stage would be disclosure. Disclosures where either party must disclose all relevant documents. Documents which support and undermine the case must be disclosed. And the objective of disclosure is to ensure transparency and allow each party to consider the evidence that the other has in its possession. And the next stage will normally always be witness evidence. Witness evidence is usually provided in the form of a witness statement, and they contain an account of what's happened, and it will be used for cross-examination purposes at trial. Witness statements will outline what the witnesses know or recalls about the events or situations, and the statements are prepared and signed by the witnesses and exchanged between the parties before trial. In some cases, the judge might consider it pertinent to have expert evidence in a case, and that expert will give its technical opinion on the matter, and their opinion will be binding on both parties. And the final stage will ultimately be preparation for trial and actually going into trial. So the next slide deals with costs and track allocations, and broadly speaking, claims are generally broken down to 3 main tracks, and they are the small claims track, the fast track, and the multi-track. So the small claims track deals with all cases that are valued up to £10,000. The court aims to deal with these cases within 6 months. In the small claims track, each party is responsible for their own costs. Now, what this means on a practical basis is that if you are issuing a claim, you think you've got a really good case, reasonable prospects of success, you're going to be successful, that's fine, but you do need to bear in mind that when you are successful, the judge won't normally award you your costs in relation to bringing that claim. You'll have to pay for your own legal costs out your own pocket, really. So really important to bear that in mind if you are getting legal representation to bring a small claim. Either party will be paying for their own costs in the small claims track. The second track is the fast track, and these are for all matters that are valued between £10,000 and £25,000. These hearings normally last 1 day, and they normally the court normally aims to reach a trial within 1 year on those matters. In the fast track, you are able to recoup some of your legal costs. Normally, the rule is that the losing party is responsible for the winning party's costs. And normally what will happen is that either party will submit a schedule, and if the judge will consider the winning party schedule and sort of allow what they consider or deem appropriate by way of costs. The third track is a multi-track, and these are for more complex matters which are valued in excess of £25,000. multi-track cases are normally listed for more than one day and take around 2 years to reach court. On these kinds of cases, we find that most parties will normally have legal representation, and both legal representatives will be responsible for filing what's called a cost budget, and these cost budgets would be approved by the court. So again, the losing party is responsible for the winning party's costs as laid out in that cost budget. So again, that budget's a really important document to make sure it's accurate, really. So I think briefly, it would again be quite handy to discuss what happens at trial. And we do find most cases will settle much before trial. Around 90% of them will settle before trial, even some cases settle on the day of trial. But ultimately, trial is just accumulation of all the work that's carried out throughout the case. You will normally have a pre-trial review before your trial with your barrister and your solicitor and any witnesses that are going to give evidence on your behalf. On the day of trial, your barrister or solicitor will represent your case. They will call yourself and any witnesses to give evidence, and then counsel will cross-examine you and your witnesses. The barristers or legal representatives will then summarise their arguments and refer the judge to any relevant law. The judge will then give their judgment or will reserve judgment until a later date if they're not able to give their judgment there and then, or if they've just not had enough time to give their judgment. Sometimes costs are dealt with on the day of trial or sometimes reserved for another day. So I will now pass over to Hami, who's going to discuss how a business can really stay ahead of a dispute arising.
Thanks, Aneela. So there's a few things that you can do to stay on top of your contractual arrangements and hopefully prevent any disputes from arising in the first place. As we all know, disputes are a headache, and we want to be doing everything that we can to stop them from happening in the first place. So firstly, regularly review your business documents and agreements. Familiarize yourself with what you've agreed to and review your business processes to make sure that you're compliant and doing whatever's required of you under those agreements. And review those at regular intervals to make sure that as your business processes change, you are still in compliance with any agreements that you've signed. Avoid oral agreements and make sure you put everything in writing. Whilst handshake agreements seem like the easy option at the time, they're not very useful if things go wrong because neither party has anything to refer back to, and ultimately it leads to a game of he said, she said, the parties have clearly interpreted things differently, but there's no way for anyone to know what was actually agreed or what the intention was at the time. It's also really important to carry out due diligence in respect of the party that you're contracting with. Know who you're entering into a contract with, know what their business is like, and understand the values of their business. Just because this person you've met this person a few times, they might be fun to hang out with at a family barbecue, doesn't mean they're a good business person. So really do your research. It's also quite useful to obtain legal advice on contracts or documents early. It's much easier to negotiate contracts before they've been entered into than to try and amend a contract after both parties have signed it. Typically, contracts will contain a variations or amendments provision, and this will set out that you need the written consent of both parties before that contract can be changed. And so if the other party then isn't willing to agree to any amendments that you're asking for, you're kind of stuck in terms of what you can change and you need to abide by the original agreement that you've agreed to. You should act quickly when there appears to be a dispute arising. The longer you let something stew, the worse it will eventually get. It's important to maintain an objective approach to the dispute and stay calm and level-headed, because getting fired up is eventually just going to make the situation worse. So that concludes the main part of our webinar. You might find our publication on how to manage a business dispute quite useful. Sorry if you've just noticed the lighting changing on my end. It's on apparently a movement sensor. We also have an upcoming event that might be of interest. So our next webinar is on the 24th of October, and it's on how to franchise your business in the UK. We're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about our membership. So LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with the other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document reviews, drafting and amending, unlimited advice consultation. So if you ever do have a dispute that crops up, or there's a potential dispute on the horizons, you can book in a call with our team and have a discussion, and hopefully avoid it getting any bigger. As a LegalVision member, you won't have to worry about the costs of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all your business's usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing any additional legal work. To learn more about how our membership can help you, request a free consultation when the survey appears at the end of the webinar. And now we're going to answer some of your questions. We've had some good questions come through. Aneela, I think this first one might be a good one for you.
Yeah, sure. Thank you, Hammy. So yeah, I'll take the first one. So it is, can you be personally liable for IP disputes for a limited company? Now, if you're a director of a limited company, you'll not normally be held liable personally for any intellectual property disputes that the company becomes involved in. Actually, the main advantage of being a director of a company is that you'll not be held personally liable. You're not, that it separates personal assets of the owners from the company's liabilities, and that does include legal disputes. So if there is any IP by way of videos, then actually this is property of the company, and you wouldn't be held personally liable for those in the normal course of things. But however, you could be held personally liable in certain circumstances, which are quite rare, I suppose. And things like that would be if you've been involved personally in any IP infringement, or if you're generally acting in any way outside of your duties as a director. For example, you're under a duty to act in a manner which promotes the success of your company. So in those sort of rare circumstances, you might be held personally liable, but in the normal course of things, no. IP disputes belong to the company, and an individual can't be held liable for those. I think, Hammy, did you want to take the next one?
Thanks, Aneela. So this next question is, have you ever found that company constitutions have been able to head off conflicts by providing clarity about governance and founder or officer rights? What more would be needed beyond the document to avoid governance disputes? So I'm going to assume that this question actually relates to Articles of Association, which is the UK equivalent of company constitutions. Now, they can certainly be a useful tool in heading off conflicts and avoiding disputes. They typically include a dispute management process that very clearly sets out what needs to happen should a dispute arise. And they also just set out what the rights and responsibilities are of each person involved with the company. They very clearly set out what rights attach to which shares, and therefore everyone knows what's expected of them based on the class of shares that they hold. A really useful clause in the Articles of Association is a compulsory transfer provision for leavers. All the time we see a shareholder resigning from their position, or they're not really performing and are therefore let go, but there's no way to force them to sell their shares. That's where a compulsory transfer provision comes into play, because it means that you can force the shareholder to sell their shares, particularly if they're a bad leaver, so particularly if they're being let go because of poor performance. Another useful document that can help avoid governance disputes is a shareholders agreement. This is a contract between the shareholders and can often be tailored to address personal circumstances. A useful provision in this is a power of attorney, which means that one shareholder receives the power of attorney over other shareholders and can therefore sign documents on behalf of the other shareholders. This can help eliminate disputes, because if one shareholder isn't agreeable on a particular matter, the others can sign on their behalf. So you're effectively technically forcing their hand. I hope that answers that one. I'm going to pass back to Aneela for the next question.
Yeah, so somebody's asked, how long are the courts currently taking to deal with claims? It is variable. Unfortunately, we are finding that the courts are extremely busy, and there is quite a big delay in processing claims. Some courts are sort of in a backlog of around 4 months. So we'd say at least 12 to 18 months ready to deal with small claims or fast track claims. The more complex matters, the high value claims, are taking over 2 years to be dealt with. And that's really why we are encouraging parties to exhaust all options before issuing proceedings, because it's not a quick resolution. It will be lengthy and take a significant amount of time, and like I said, the courts are severely delayed. So yeah, we are finding sort of at least up to between 12 and 18 months for those cases to be resolved, which isn't ideal, but that's the current sort of time frames that we're looking at, really. So I'll pass back to Hami to deal with the next question.
Thank you. So we've got a couple of questions ready to go that have already been submitted, but if you do have any more, now is your chance to submit them in the chat box, and we'll try and get through as many as we can in the time that we have today. So the next question we have is my verbal contract enforceable? Whilst verbal contracts are enforceable, they're often quite difficult to prove. The parties will take the matter to court, and the court will need to consider what the intention of the parties at the time they entered into that contract. But if there's sort of no contract in place, the court will need to look to any written communications between the parties, so whether there's any emails or WhatsApp messages or things like that. And oftentimes it can be difficult to decipher these. So if at all possible, it is always best to have a written contract, because it just avoids or the headache of going back and forth and trying to determine exactly what the parties meant when they said this or that. So the short answer is yes, verbal contracts are enforceable, but it can be difficult and you may not always get the outcome that you're looking for. Aneela, do you want to take this next one?
Yeah, the next one is, can you explain the process in enforcing court judgments? So yes, I mean, if you got the judgment, then that's great news. And once judgments have been obtained, payments not been received, you can go ahead and take steps to enforce that judgment quite quickly. If your judgment is against a company, I suppose there are lots of options for you. A good option would be to try and enforce via a third-party debt order, and that's an order which freezes money held by an organisation. The order will prevent the debtor having access to that money until the court makes a decision about whether the money should be paid to the creditor or not. It's a useful one to use if you have got your debtor's bank account details and you think that they have funds in there, and it's a relatively quick one. It just involves an application to the court, and the court will normally have a hearing to consider whether that order should be allowed, and we find that that's quite a successful way of enforcing a judgment. Another route could be enforcing via High Court Enforcement Officer, or also known as bailiffs, and this can be used if the debt is more than £600. Bailiffs are allowed to force entry to commercial premises to see if there are any goods of any value there, and they're able to seize those goods and sell them online or via auction, and the proceeds are given to the creditor to pay that debt ultimately. Again, it's only useful if you do believe that the company has any assets of any value there. Another option would be a charging order, which is where a charge can be secured against the property of the debtor or any property that he owns, but the money will only be released when the property has been sold, so you won't normally be able to get that money sort of quickly. It'll only be when that debtor tries to sell the property will the funds be released to you. And the final sort of way of enforcing would be a winding up order. The value of the debt needs to be more than £750, and the court will seal a winding up petition and serve it upon the company. And it's a legal order issued by a court to ultimately dissolve and liquidate a company, and it's probably one of the most effective methods because companies don't want that to happen if they're still trading, and it'll normally always prompt a response from your debtor to either agree a payment plan or try and pay something towards the debt. So that's a really good one to bear in mind as well. I think Hami's got another question as well.
Yeah, sure. So this one asks, what is a settlement agreement and what should it include? So we did briefly touch on this earlier. A settlement agreement, otherwise known as a deed of settlement and release, is a document which sets out what agreement the parties have come to resolve their dispute. So this may include some sort of settlement payment or some other action that the parties have agreed to take. If a party has agreed to pay a sum or supply a certain amount of goods, that needs to be set out in that settlement agreement. Ideally, the agreement should also include a release, which is a promise by the parties to not bring any more claims against the other party or against each other in respect of that particular dispute. The benefit of having a settlement agreement is that it is of itself, if created correctly, a legally binding document, meaning that if a party does fail to comply with their obligations under the settlement agreement, the other party would have a claim against the first party for breach of the settlement agreement. So you can then issue a new claim, and whilst it's a headache going through that process again, that option is open to you if you have a settlement agreement in place. I think that's probably all we have time for today. Thank you so much for your questions. It has been really great. After the webinar ends, a survey will pop up. We would really appreciate it if you could complete the 30-second survey. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you with your commercial disputes. Thanks so much for joining us.
Thank you.